With that, I'll call the first case on this morning's docket. It's case number 128963 out of Johnson County, Gunter Construction Company, appellant and cross appellee versus City of Lenexa, appellee and cross appellant. Would the parties please state their appearances?
Your Honor, Eddie James for Gunter Construction Company.
Good morning, Your Honor. Daniel Bowler, LLP, joined today by Sarah Otto of the same firm, City of Lenexa, Kansas.
Thank you. Counsel, I understand that this case has both an appeal and a cross appeal. Has there been any discussion? How do we want to treat this argument?
Well, I thought I would speak to both issues in my case, in my argument in chief, and I would reserve 3 minutes to address any issues they raise and try to be as efficient as we can.
Thank you. And do you want to just address everything all at once, Mr. Bowler? Okay.
That's what I intend to do, Your Honor. Mr. James' plan sounds good.
Okay, thank you very much. Well, with that, Mr. James, you may approach and go on ahead and start your argument.
Good morning. May it please the court. My name is Eddie James, and I'm here on behalf of Gunter Construction Company. I have with me in the courtroom Stephanie and Christina Gunter at the very back, who are the owners of Gunter Construction Company. Your Honors, this appeal poses some fundamental questions. Kansas's legislature has said no damages for delay clauses in public contracts are void and unenforceable against public policy. And the question to this court is, can the City of Lenexa rewrite its public construction contract with Gunter so as to avoid the Kansas Fairness in Public Construction statute? What do I mean by that? The contract never uses the words road, highway, or bridge. But the city would have you read these terms into the contract it drafted to label this trail a road, highway, or bridge.
It is called the 95th Street project.
Right, but in this description of the scope of work, I mean, it is a trail that connects different parts of the city of Lenexa.
And the scope of the project, I think, includes a pedestrian crossing across Lackman Road in Lenexa, and then a pedestrian refuge station, and then also pedestrian activated flashers. So, but for the road, we wouldn't need any of those things, would we?
Well, Your Honor, that with any project of any size like this, there will be certain interactions with streets and public right-of-ways. There's no question about it. But it's clear in the scope of work that this is described as a non-vehicular trail, right? It's not a road, highway, or bridge that the city would have you believe.
It was my understanding from reviewing the record in this matter that we call it, the project uses that phrase that you just did, a trail for non-vehicular traffic. But isn't this just a widening of a sidewalk?
Well, it
runs both along Lackman Road and then along 95th Street.
It runs along certain areas near Lackman Road and 95th Street. But if you look at the Kansas statutes, KSA 8-1459 says a roadway must support vehicular traffic. There's statutes that speak to this very issue. But
isn't there also a statute that says that when you're talking about the road, that includes the right of way?
Right, but there are statutes that say that, but parts of this project were not in the right of way, Your Honor. So
it was my understanding. Was there any part of this project from its conception or from its beginning in 2019 that was not in the right of way, or was that just the kind of access sidewalk that was added after the fact?
I believe there were parts that were always not in the right of way associated with this project, Your Honor. And And so, but I think these are good questions.
But what are those? Because that's important for us to know. So
Well,
what were those?
When on the record, when the city was deposed by its representatives, it said this was not a road, highway, or bridge project.
That doesn't govern, that's a statement by a witness. That doesn't govern the ultimate legal question, does it?
Well, I mean, Your Honor, I think if the parties, the parties are asking, the city is asking the court to look outside the contract and say that this was a road project. And so it does, if the contract is ambiguous as to whether this is a road project or not a road project, then you would look to the parole evidence and the testimony of the people involved in the project and the people involved in drafting the contract and putting it together. I mean, I think that's what the trial court got wrong in terms of granting summary judgment on the issue of that this was a road and also that it contains section 109 is these are, if that is the question, if it is a road, then that's a question of fact because it's not in the contract that it's a road project. It's not in the contract that it's a bridge project. And so renders an ambiguity, which makes it inappropriate to grant summary judgment.
So are you saying that parties through a contract can contravene a Kansas statute? That's the logical conclusion of what you're saying.
No, I am saying I am pro Kansas statute in the sense
We all are, counsel.
right that I believe the Kansas statute here, I believe the city is trying to rewrite the contract to contravene the Kansas statute. I believe the city, by arguing that the Kansas Fairness in Public Construction statute does not apply, is trying to contravene the legislature's intent with this project that's not a road, highway, or bridge.
So let's pause for a second. So when we talk about the act, the act specifically excludes roads, highways, and bridges.
Right.
But roads is not defined in the act, correct?
It's not defined in the act and not defined in the contract, Your Honor.
Okay, so then what legal maxims should this court employ in determining whether this project is a road?
Well, the legal maxims that we suggest this court would employ is what is common sense and a reasonable interpretation. If a juror was looking at this case, a fact finder, I mean, the statutes are clear. I mean, the case law is clear that you should use a reasonable interpretation of the statute.
Unless
right?
the legislature has defined that term for us.
But they haven't. And the city could have defined that term in the contract. The city could have written in the contract, this is a road project and outside the jurisdiction of the Kansas Fairness and Public Construction Statute.
Can we talk about the scope of the project a little bit? Is there any dispute that this project was a federally funded project that worked through KDOT?
I don't think there's any dispute about that, but look at the federal funding sources for this project. It was green energy, it was for encouraging bicycles. I mean, that's what the record reflects.
But is there any question that I understand that you're focusing on the contract, but the greater project itself was in fact subject to 109 and thus was exempt from application of the act?
I'm glad you moved to that, Your Honor. No, the answer is no. There's nothing in the KDOT agreement with Lenexa that says section 109 applied. How was Gunter to know when it bid this job if it's not in the contract? They did put special provisions in the contract documents, Your Honor, just not section 109.
But I'm talking about the greater project itself, not the specific contract between Gunter and the city of Lenexa.
Right. There's nothing in the record saying that section 109 applies to the greater project itself. They would have you believe that it says that, but ask them where in the record does any document say section 109 applies to this contract?
Under the act, is there a requirement that your client knew it was a section 109 project?
No, I don't think the act, Your Honor, I don't think the act requires that we know. But I think you can't read the contract is the contract between Gunter and the city of Lenexa is really what this case is about. And you can't read terms and words into the contract that aren't there. And that's what the city is asking you to do to avoid what the legislature's public policy pronouncement that these no damages for delay clauses are void and unenforceable. They want bidders to bid these jobs. And if these onerous one-sided provisions are allowed to be enforced, I mean, the city said in its reply brief that this was a negotiated contract. That's just not true. There's nothing in the record showing this was a negotiated
But
contract.
it was a bid project. It was something that your client bid for, knowing that it was going to be working with a public entity,
Right,
knowing that it was going to be a project that went along Lackman Road and 95th Street.
right. But knowing also that the Kansas Public Prompt Pay Act says no damages for delay clauses aren't enforceable on public projects. And looking at this project and saying it's not a road, highway, or bridge, as a common reasonable person would do, as the cases suggest that's how we should interpret the statutes. I mean, we have a statute saying a roadway is for vehicular traffic, and this is a trail not for vehicular traffic. We have the statute saying,
Council, would we be having a different conversation if this was just straight up replacing of sidewalk?
would we have a different conversation if this was straight up replacing of sidewalk? I think so. This is a trail. It was designed to be wider for bicycles, and I mean, it's a different entity than a sidewalk. Certainly, it replaced.
If it was, the sidewalk was 5 feet wide, and then this new trail or path or wide side, whatever we want to call it, is 10 feet wide. At what point does the width of the walkway tip it one way or another?
Right. I mean, that's a good question. But I think here, the parties, the contract uses the word trail. It doesn't use the word sidewalk. It doesn't say sidewalk widening project.
What if
It says-
what if it used the word spaghetti? Does it matter? I mean, at the end of the day, we're just looking at what happened, not necessarily what the language was that we used to describe the thing. Just is the thing, does it fall within what the law describes as a roadway project or not?
It is not a roadway project. It doesn't fall into what the parties or the law describes as a roadway project. I mean, I think they are asking you to read words into the contract and into the statute that aren't there. And they could have, the city could have contracted to prevent this. This was, as you noted, a public contract. We can't negotiate the terms because it's apples to apples with the other bidders, right? We can't have different terms than everybody else. So the legislature has carved out protections for contractors like Gunter Construction under these very circumstances. And it means something, because if we don't have the Kansas Fairness and Public Construction Statute in play, then there's no remedy for attorney fees or interest. And a city can make a case that was, lasting 4 years, very difficult for these contractors to pursue. So this matters. It is an important issue to the contractors, which is why we have the amicus brief filed by the National Utility Contractors Association Regional Chapter. So I see that I'm out of time. I appreciate the court's questions, and I'll see you all in rebuttal.
Are there any other questions from the panel before? All right. Thank you very much, sir.
Thank you.
Council, you have 15 minutes.
Thank you, Your Honor. Good morning, and may it please the court. My name is Daniel Buller of Folston Siefken LLP here on behalf of the city of Lenexa, Kansas. And Your Honor, I want to jump in, but take a quick step back from where opposing counsel spent his argument, and that is there are two questions for this court on appeal. The first is one. So first of all, Gunter's claim against the city in this case is that the city failed to remove underground utility lines that conflict with the project area. That's the predicate of Gunter's claim. There are two questions for this court, and this is a single claim for breach of contract. The first is whether under the terms of the contract, the city was obligated to identify and resolve utility conflicts in the project area prior to Gunter commencing work. That's a preliminary question. That's a question that does not rely on or hearken to the act. If the answer to that question is no, Gunter's claim must fail. The second question is the one that Mr. James spent his argument on, and that is whether the limitations on liability in the contract preclude Gunter's claim. And that's where the act and its public policy pronouncement relating to provisions against delay damages comes into play. As to the standards of review are well established and straightforward. The parties to a contract the court is to evaluate the intent of the parties at the time of the contract. And in this case, moving to that first question, whether the city as an initial matter was obligated under the contract to remove utility conflicts, the city was not.
Counsel, is that normally the type of controlling question of law that we would consider in an interlocutory appeal?
In this case, Your Honor, I think it is appropriate to consider the contract question because it is part and parcel to Gunter's claim. Now, I understand that there are statutory questions that are novel before this court, but this is a matter before the court on appeal. It has generated some interest, not only because of the applicability of the act, but because of the widespread use of or the terms that are at issue relating to which party to a public works construction contract has the obligation to resolve utility conflicts.
Here's where I'm struggling with that, is because we can read the language of the contract, right? I mean, that's certainly something we can do, but the district court found that there are some factual questions that preclude summary judgment on that issue. For example, there are at least facts that put into question whether the city undertook that responsibility independent from the contract. That's not something we want to wade into until there's been a final judgment on the matter. So why is it that we should take up that issue now?
Because the terms of the contract at the time of the parties contracting control their obligations in this case. And if those terms are clear and the district court misapplied those terms, then it is the obligation of this court to evaluate and ascertain the obligation of the parties.
Once there's been a final judgment, but that's not the typical, I don't want to spend all your time talking about this, but I want you to know that it's something that I'm concerned about. Because one of the things that we have to think about is what would happen if we were to take up that issue in this case. Does that mean that every time a district court denies summary judgment on a contract claim, that comes before us by way of an interlocutory appeal citing this case? And that's not a door that is a good door to open.
Not at all, Your Honor. And I don't disagree with that. However, in this case, what we have, and if you look at how the district court got to the ruling denying the city's motion for summary judgment on the utility conflicts issue, Gunter relies on an order of precedence provision in the contract that places all laws at the top, and then it sort of pivots from that to a city ordinance. Okay, and that city ordinance was key to the district court's decision that that summary judgment was not proper. That ordinance. So the question for this court is, what do the terms of that ordinance mean, and how does it relate to the party's legal obligations under the contract? And that ordinance, it does not support any pre-existing obligation by the city to resolve or identify utility conflicts. That ordinance, Your Honor, is ordinance 4-6-I-10. And it never says that the city must identify and resolve utility conflicts. There's no conflict with that ordinance and the terms of the contract. That's just ordinary basic contract interpretation. In fact, subparagraph E of that ordinance, which Gunter does not include in its brief, but we included in our reply brief, includes important provisions that sort of lay bare why that ordinance is irrelevant to the interpretation of the contract here. And it provides that so the city will work with subparagraph A, the city will work with utility companies in advance of a construction project. But subparagraph E says, in the event that utility companies fail to remove conflicting utility lines, the city may, at its option, remove or cause to be undertaken the removal of those utility conflicts. That is exactly what the city did in this case by contracting with Gunter, when Gunter agreed that it shall be responsible for identifying and resolving utility conflicts. And the ordinance never says that the city will be liable in the event that the utility conflicts are not resolved. To the contrary, the ordinance says that under no event will the city be liable for that, okay, to the contractor or anyone else. In the event that utility conflicts are not removed, the ordinance that Gunter relies on says that the city shall not be liable. So that's subparagraph E. There is no conflict between the ordinance and the contract, which states that the parties agree that Gunter shall be responsible for identifying and resolving all utility conflicts. And there is no provision in the contract that says at any place that the city shall be obligated to undertake that responsibility. And without a provision that is an alleged breach, a breach of contract claim must fail. That's doctrinal law in Kansas. And so it's the city's contention that as a preliminary matter, the court should evaluate the plain language of the contract, apply it, and if there is no valid breach of contract claim, dismiss Gunter's claim in this lawsuit. That's the utility conflicts, and that's irrespective of the act. Moving to the second question, which is, does the limitations on liability provision apply? In this case, there are a number of provisions in the contract that address this issue. So general condition number 34 provides that if the contractor shall be delayed at any time in the any time in the project, no adjustment shall be made in the contract price. And additionally, quote, contractor represents that its bid includes all costs, overhead, and profit which may be incurred throughout the contract time. Accordingly, contractor may not make any claim for delayed damages based in whole or in part on the premise the contractor would have completed the work prior to the expiration of the contract time, but for any claim delay, whether caused by the city or any other cause. That's GC 34. GC 29 specifically calls out utility companies. If the work of the contractor is delayed or damaged by any acts or omissions of any other entity, including utility companies, contractor shall have no claim against the city. What that shows is at the time of the party's contract, they specifically contemplated.
Counsel, those provisions don't matter if the act applies. Those provisions are illegal if the act applies. So ultimately, the question is, does the act apply?
Yes, that's correct, Your Honor. If the court construes them as delay damages, the act must not apply in order for those provisions to be valid. No argument there. And that gets to the road issue, and that gets to the Section 109 issue.
Why did the city call this a trail?
Well, there are probably two reasons for that. One certainly is because this is a sidewalk project that connects existing trail systems. For example, the Sarco-Par Trail Complex, the trail complex at the Sarco-Par Park at 87th and Lackman Road. This sidewalk connected that trail system to the one across the street and down on the southwest corner of the project at Lackman Road.
Doesn't that weigh against the conclusion that this is essentially just the widening of a sidewalk?
Constructing a sidewalk that connects existing trails is a sidewalk project. And there are numerous reasons why, and with respect to opposing counsel, the legal maxim that the court should use to determine whether this is a road project is not common sense. The legal maxim begin with Supreme Court precedent, look at the statutes, apply imperi materia, and look at black letter law. And those are issues that all support the conclusion that this is a road project.
What does the court do when we are faced with some parts of this project that appear to just be widening of a sidewalk from 5 feet to 10 feet, and some parts of the project connecting to additional trails and different parks, connecting the project to pickleball courts. Those wouldn't fall into that right-of-way provision. What do you do with that? Does that mean that the whole thing is one or the other? Do we segment those provisions out?
So certainly good questions, Your Honor. In this case, what we have and respectfully, the only indication in the record that any part of this project falls outside of the public right-of-way is pursuant to change order number 3. That was a change order that added about 50 feet of sidewalk that connected the main part of the project to the pickleball courts. Okay, and yes, that piece is not in the public right-of-way. The entirety of the remainder of the project is in the public right-of-way. Change order number 3 was executed by the parties 4.5 months after they executed the primary contract herein, and it represents less than 0.5% of the total cost of the project and less than 1% of the total distance of the project. That's the scope of the project that exists outside of the right-of-way, and at the parties contracting, all of it was in the public right-of-way. So in this case, we have, and we cited in our brief, a number of different sources in which the Supreme Court in Davies v. City of Lawrence held that the sidewalk is part of this a street project, and in the public right-of-way piece of that was relevant to that holding. Clip v. Hoyt, which is an old Kansas Supreme Court case, held similarly that the city in a construction project has the right to, in a street construction project, that covers a sidewalk as well.
So I'm going to stop you to make sure we have enough time to hit section 109. So as an alternative basis for its decision, the district court said, well, if nothing else, it's a construction project under the act and it is a section 109, and so it's excluded. So cover that for us.
Sure. So as you indicated, section 109 is the second carve out that potentially gets this project outside of the act. And Mr. James focused on the contract, okay? But the statute focuses on the project, okay? The project. So KSA 16-1907 says that, I'm sorry, KSA 16-1908, the very next section after 1907 says that this act shall not apply to projects that are required to comply with section 109 of KDOT's special provisions to the standard specifications. So the question is whether this project was required to so comply. The KDOT contract indicates that it was. We cited a specific provision in the KDOT contract that says that all of the standard specifications and all of the special provisions of the Kansas Department of Transportation are applicable to this project. So this project was required to comply with section 109, and this business of special provisions versus standard specifications, KDOT standard specifications define special provisions as simply amendments to the standard specification. That's all they are. And if they are, and as a result of that, it's like a statute saying this shall apply and all amendments thereto. Okay, so section 109 included information requiring certain certification for payment that is made upon invoice. That section 109 provision, it required a KDOT form 1010. That's why it's discussed in the briefs, and it supports this project being a section 109 project. So I think it's clear not only from the language of the KDOT contract, but from the other facts as well that this is a.
Counsel, I understand that you're, and I understand that we're running out of time, but I understand that your argument is that, you know, it applies to the project, not, and so if the project is subject to 109, then that means that the contract necessarily has to be. I understand kind of that nesting argument, but that does make it difficult for the contractor if you don't know whether the project is subject to this provision or not. I mean, it's kind of puts them in a difficult situation, doesn't it?
It only puts them in a difficult situation if they presume they shouldn't have to comply with the terms of their own agreements. In this case, Gunter agreed to these delay damages waivers, it agreed to all of these limitations on liability. Yes, the statute declares such provisions to be void unless exception applies. So my response to that is contractors are bound to the terms of their contracts, just like everyone else is under
But
those
of course,
scenarios.
I mean, then there's also an expectation that the parties to a contract are bound by the law that applies to that contract. And if so, do you understand that? I mean, like if a contractor, whether it was a city or a county or someone else, was tried to slip in terms that were contrary to the law, and I'm not saying that that's what Lenexa did, but I mean that also, parties should know better.
Parties will be bound to the law, and the law in this case includes 2 carve-outs for the act. And so that's my response to that concern, I suppose.
Other questions from the panel? All right, thank you.
Thank you very much.
Council, you've reserved 3 minutes for rebuttal.
Thank you, Your Honor. I want to address, if I can, their first argument that there was no duty on the part of the city, that the question of duty is out there. And the trial court was wrong in saying that was a question of fact. And I agree this is a strange time to bring that up. And the documents suggest that there was a duty on behalf of the city, and the court found those documents compelling. There was not only the ordinance, there was Kansas statute 17-1902, and then we have the KDOT agreement, which says the city is supposed to relocate the utilities before the project is let for bid. Before the project is let for bid. So that's volume 1338-54. Then we have the representation to KDOT that they relocated the utilities before the project was let for bid. And that is volume 26, page 90-93. So we have this affirmative duty arising by ordinance, by contract, and by statute that they're going to relocate the utilities. They didn't do it. They tell KDOT they did it. And then Gunter is damaged. I mean, this is why the majority rule across the country is that when an owner actively interferes in a project's work, a contractor's work on the project, that the no damages for delay clauses won't apply. And we argued that, and the NUCA argued that. And those are fact issues as well, Your Honor. So that is why there's a duty. The trial court was right to deny summary judgment, and their appeal on that is wrong. The trial court was also right to deny summary judgment on the issue of whether what type of damages are out there, whether delay damages or acceleration damages or inefficiency damages, and that's for a jury to resolve. And that's also not something that is good grounds for appeal, because that's a question of fact. There's evidence showing the damages were our experts said these were like a portion were delay damages and a portion were not delay damages. So we have that issue as a fact out there. Now, going back to the issue of section 109, if you'll look at the KDOT agreement that he's talking about, which he says binds the project to, it doesn't say that the special provisions apply. It doesn't say the section 109 applies, actually. If you look at it's on page LEN 06251. It says special provisions required by the secretary or by the city with the secretary's concurrence. It doesn't say section 109 applies. So that argument should fail, right? The district court, I think, was confused by their argument. The order reads a little awkwardly, and I think that argument should fail. And then going to the issue where this is whether this is a road or not a road. Oh, I'm sorry, I'm out of time, but I'll just.
You may briefly conclude.
I'm sorry. Yeah, the reasonable person, the person on the street would say this trail going it was not a replacement. It was not a mere sidewalk replacement. A reasonable interpretation would be like, this is a trail. It's double the size of what was there before, and it goes through areas that were not in the right of way. So whether it's by contract or by change order, which become part of the contract, Your Honor, that issue is out there, and I think it creates an issue of fact for the jury to resolve. I think issues of fact preclude summary judgment granted by the trial court. Thank you.
Thank you very much. I want to thank all counsel for their arguments today. This is an interesting case. We will take the matter under advisement and we'll issue an opinion as soon as we're able.
Thank you,
So
Your Honor.
thank you very much.
Thank you, Your Honor.